maternity leave continues to present a complex issue for employers, and this certainly played out in the recent federal court case involving fashion retailer Scanlon and Theodore, with an employee claiming that the fashion house was hostile to her and then terminated her employment after she announced her pregnancy and intent to take maternity leave. Well, let's get some more on this case, what businesses and employees need to know. We are joined by Joy Deep-Hoare from People and Culture Strategies, Managing Principal of the specialist law firm. Of course, Jodie, great to see you as always. Just firstly, could you give us some of the details surrounding this case? What happened? Yeah,
so in this particular case, a female employee took a period of parental leave or maternity leave. She came back to work. Within a few months, she was advised by her employer that her position was to be made redundant, so her employment was to be terminated. She claimed that, having regard to a number of incidents and behaviours that had transpired upon her return, where she alleged that management had treated her, she said, with disdain, that she had been targeted for redundancy as a result of her taking parental leave, and she argued that that amounted to a breach of the adverse action provisions of the Fair Work Act, which are a form of anti-discrimination remedy, for want of a better phrase. The Federal Circuit Court looked into this, considered the evidence very carefully and said, no, this was a genuine case of redundancy. They looked very closely at the employer's financial performance. They said a number of people had been laid off. The employer had been quite transparent with her, and that this particular employee was found to be prone to embellishment. The other thing, though, that was really important was that the employer got a lot of brownie points with the court for having a very good track record of reintegrating women back into the workforce after they had taken a period of parental leave. So all of that worked in the employer's favour. But it really does serve to remind all employers that this is a particularly complex area, and it's going to be dangerous at the best of times to implement redundancies. But when you're looking to make someone redundant who has been out of the workforce, has come back for a short period of time, a lot of new parents and new mothers will appreciate that that is a difficult time, that there's a lot going on in your life, a lot of pressures, and you've been out of the workforce for quite some time, and so you feel that perhaps that has worked against you, and that had you been in the workforce and not taken that period of parental leave, well, maybe you might not have lost your job. So employers do need to tread really carefully around that, and it doesn't necessarily mean that employees coming back from parental leave are a protected species, but a heightened level of care and caution is warranted.
You were talking about the fact that what worked in the company's favour in this case was that they had a clear track record. So is this something that a lot of businesses do struggle with, though, in terms of dealing with the issue of maternity?
They do struggle with it, and they struggle with it at a number of levels. The first level is how you actually manage the transition. So someone goes off for a period of time, and that could potentially be a period of up to 2 years now. So an employer faces a high level of uncertainty around when the person's going to come back, indeed if they are going to come back. So what do you do with their work? What do you do with their internal and external relationships with customers and clients and suppliers and things like that? So that's a major watch out. Then when the employee comes back, regardless of when that period is, well, the law requires the employer to put them back in the same position that they were in prior to going on parental leave. It doesn't matter how long they've been away for. Now, it's only if that position doesn't exist can the employer transfer them to another role, but that's meant to be equivalent. So employers feel that it's unfair to them that their organisations have to cope with that level of disruption, and there's a perspective often expressed to us that, well, who's looking out for the employer's interests in this? Now, of course, these are laws that have to be complied with. Everyone's entitled to their own views as to whether they're good or bad, but it is a challenge for employers. They have struggled with it, and where it starts to get confusing is that often the issues around payment as to paid parental leave or unpaid parental leave dominate the headlines of discourse around this particular issue, whereas in my experience the real challenge is how the employer manages the transition, both the transition out as the employee leaves and the transition back in when they come back.
Yeah, absolutely. So in terms of regulation, I mean, what do employers need to bear in mind? What are their obligations to the employees?
So the payment part is something that is dealt with under separate legislation to workplace relations legislation, and effectively that is a form of a social security payment, although that's channelled through the employer. That's a fairly procedural aspect. The real challenges are making sure that when the employee is away from the workplace, that the employer, I think at a practical level, keeps in contact with that particular employee if there are going to be organisational changes happening at that particular point in time. And then the real watch-outs are when that employee comes back. Be very mindful that your obligation is to return that employee to their pre-parental leave position if it exists. If your organisation has restructured, well, you can't just say, we've restructured, therefore your position is gone, you no longer have a role. You have to, you have a positive obligation to find that employee a comparable role, having regard not just to pay and title, but also to perceived status. A very famous Australian case involving Orica many years ago, where they were found to have discriminated against an employee coming back from parental leave. Notwithstanding they returned her to the same position and the same pay, they discriminated against her because they'd rejigged her customer portfolio, and she claimed that that was a significant diminution in status.
What about in terms of if an employee wants, to come back on a more flexible basis, say part-time, or I mean, how does that work? What do employers? Correct.
So that's effectively treated as a separate right that employees have, and it's not immediately connected to parental leave. Anyone who has carers' responsibilities for children under school age, and in fact this is all going to expand come 1 January, courtesy of some reforms that were introduced earlier this year. But if they do have such carers' responsibilities, then they have a right to request a change to their working arrangements to accommodate flexibility. And an employer, for all intents and purposes, is required to accept and agree to that request unless they can show they've got reasonable business grounds for doing so. And it's not easy. Mere convenience or inconvenience is not going to be a material factor. An employer's got to really show that their business is going to suffer in dollar terms in order for them to say no to such a request.
Yeah. Very, very topical. Great to hear that from you, Joydeep. Thank you so much for explaining a bit more about that. Thank you.
Pleasure. Thanks,
Joydeep Kaur, their Managing Principal of specialist employment law firm People and Culture Strategies there. We're going to take a quick break here.